Hello everyone, I'm Will Grishevsky, and today we will be covering false advertising within the food industry. We will share two different cases that help to highlight key points within false advertising law. First, what is false advertising? It is often defined as a false or misleading statement in a commercial advertisement about one's own products or about the products of a competitor, and that it has a tendency to influence purchasing decisions and has caused or is likely to cause injury to competitors. There are quite a lot of nuances within false advertising law, causing businesses to cross the line from ads that only highlight the positives about their product to ads that are outright lying about the product. We chose to focus on false advertising within the food industry because we noticed that there had been an uptick in false advertising food and beverage cases over the last few years. 2020 alone had 220 cases, up from 2019, which had 177. 2018 had 164, and 2016 and 17 had 145. To put this into perspective, 2011 only had 53. So we decided to look back at some of the most notable false advertising cases within the food industry over the last 2 decades and learn what is at the root of this uptick. The first case we will cover is from 2009 and is a class action lawsuit filed against Kellogg's for false advertising in their commercials. First, let's watch one of the commercials under fire. You may notice that the kid in the commercial is played by Noah Monk, or Gibby from iCarly.
Where were we?
We were on the third paragraph of page 57, and you were explaining that the stone structures made by ancient Romans were called aqueducts. And as you're writing that up on the board, your chalk broke into 3 pieces.
Right.
I've never been so proud.
A clinical study showed kids who had a filling breakfast of Frosted Mini-Wheat cereal improved their attentiveness by nearly 20%.
20%? Okay, even I'm impressed by me.
Keeps them full, keeps them focused.
The complaint was first made by 2 sets of parents who were upset at the misleading commercials. The complaint alleges that, in fact, according to the clinical study referred to in the Kellogg's ad, only about half of the children who ate Frosted Mini-Wheats for breakfast showed any improvement in attentiveness at all, and only about 1 in 9 improved by the 20%. Journalist Michael Moss surveyed adults about their thoughts on the ads and found that 51% of the adults surveyed were not only certain that the claim about attentiveness was true, but that they believed that it was only true for Frosted Mini-Wheats. This complaint was also reported to the FTC, who filed a class action lawsuit against Kellogg's for false advertising in their Mini-Wheats commercials. The FTC found that Kellogg's was in violation of Section 5 and 12 of the Federal Trade Commission Act, which are unfair or deceptive acts or practices in or affecting commerce and the dissemination of any false advertisement that is likely to induce the purchase of food, drugs, devices, services, or cosmetics. They were also in violation of Title 15, Section 45 and 54 of the U.S. Code, which are unfair methods of competition and false advertisements. The FTC filed an order that prohibits the respondent from making any representations in advertising for Frosted Mini-Wheats or any other morning food or snack food about the benefits, performance, or efficacy of the product for cognitive function, processes, or health unless the representation is true and non-misleading. In addition, the respondent must possess competent and reliable scientific evidence for such claims. The order also prohibits the respondent from making misrepresentations in advertising for any morning food or snack food about the existence, contents, validity, results, conclusions, or interpretations of any test, study, or research. And it requires the respondent to keep copies of any relevant advertisements and materials substantiating claims made in the advertisements. The issue is that Kellogg's misrepresented studies used in their commercials and was misleading about cognitive health claims for Kellogg's breakfast foods and snack foods, and failed to include any disclaimers which would have informed the customers of inaccuracies in the data. The rule the court provided was that the acts and practices of the Kellogg Company constituted unfair or deceptive acts or practices and the making of false advertisements in or affecting commerce in violation of Sections 5A and 12 of the Federal Trade Commission Act. The rule in this case created equity in that it created clarity between consumers and the information about the product they're buying. It also resulted in the small refund of $15 to anyone who purchased a box of Mini-Wheats from 2008 to 2009 in order to compensate the frustrated customers who were misled by these false claims. Immediately after the case, Kellogg's released a new set of commercials with their new legal fact about Mini-Wheats. Keeps them full, keeps them focused. Basically saying eating Mini-Wheats is better than eating no food at all. But Let's watch the commercial and see for ourselves.
Bye, Mom. Bye, sweetie. You'll do great.
This is it.
A new school year has so much potential.
Hey, any resolutions? My resolution is the same as always. Keep her full and focused with my fiber. 3, 2, 1. Happy school year!
This school year, make a resolution to give your kid Kellogg's Frosted Mini Wheat cereal, an excellent source of fiber from 100% whole grain that helps keep them full so they can focus on the day ahead.
Keeps them full,
Keeps them focused.
Their New Year's resolution should have been, let's stop false advertising. Unfortunately, Kellogg just can't help themselves because in the years following the case, Kellogg's have been the target of multiple class action lawsuits pertaining to false advertising with Pop-Tarts and most recently with the amount of sugar that their cereals have.
Hi, my name is Parker Sherritt, and the second case we will be going over is between Condoleezza LeGrand and others versus Abbott Laboratories. So to get started, the relevant facts of this case include that it involves a class action lawsuit brought by two plaintiffs, Condoleezza LeGrand and Larissa Bates, against Abbott Laboratories over its line of nutrition drinks sold under the brand name Ensure. The plaintiffs allege that Abbott's labeling of the drinks as healthy and nutritious is false and misleading, as they contain up to 22 grams of sugar per serving, which scientific evidence suggests is harmful to overall health. Abbott is an Illinois corporation with its principal place of business in Abbott Park, Illinois, and sells Ensure nutrition drinks nationwide, including in California and in New York. The plaintiffs are a California resident and a New York resident, respectively, who purchased Ensure nutrition drinks in their states within the 4 years prior to filing the lawsuit. The plaintiffs seek to bring a class action lawsuit on behalf of themselves and other consumers who bought Ensure nutrition drinks during the class period defined as the 4 years preceding the filing of the complaint. The plaintiffs bring several causes of action, including a violation of various California and New York state laws, breach of express and implied warranties, unjust enrichment, and negligent and intentional misrepresentation. The issue in this case is that advertising for Ensure products falsely implied that they were nutritionally complete and equivalent to a balanced meal, when in fact they contain high levels of sugar, as discussed before, artificial flavors, and other unhealthy ingredients. The plaintiffs also allege that Abbott Laboratories violated California Consumer Legal Remedies Act and unfair competition law by engaging in false advertising and deceptive business practices. So the rules in this case that are discussed are Rule 12b2, which pertains to dismissing a lawsuit for lack of personal jurisdiction. The plaintiff must prove that the court has jurisdiction over the defendant, but only needs to make prima facie showing of jurisdictional facts to avoid a dismissal. Courts can exercise personal jurisdiction over a defendant if it is allowed by a long-arm statute and does not violate federal due process. In this case, the plaintiff has brought false advertising claims under California and New York law. The defendant seeks to dismiss these claims on multiple grounds, including that the alleged false advertising statements are not misleading, that the federal law preempts certain statements, and that the pleadings are insufficient under Rule 9b, which I will go over shortly. The defendant also argues that the plaintiff lacks statutory standing for the products she did not purchase. So Rule 12b6 allows defendants to move to dismiss a complaint for failure to state a claim upon which relief can be granted. And Rule 9b, the plaintiff must provide specific details about the who, what, where, when, and how of the alleged fraudulent or mistaken conduct, which they were not able to apply sufficiently. How does this case create equity? This case aims to create equity by seeking to ensure that consumers are not misled by false and deceptive marketing practices and that they are provided with accurate information about the products they purchase. It also seeks to hold corporations accountable for their actions and to provide consumers with the means of seeking redress when they are harmed by such actions. Additional information and key takeaways. Consumers claimed in court that Abbott Laboratories Ensure drinks, labeling them as balanced, nutritious, and healthy, was deceptive and misleading because of the increased sugar level. They made this claim in relation to the company's Ensure drinks. Numerous defenses were brought up by Abbott, including lack of standing, preemption of claims based on state law, and inactionable puffery, but many of these false advertising claims were upheld despite the request to dismiss. Companies must be aware of the Federal Trade Commission's responsibility under the FTC Act to regulate false advertising and dishonest business practices. Companies should carefully plan their marketing strategies and engage with marketing attorneys to ensure compliance with regulatory standards in order to avoid making false advertising claims. In conclusion, deceptive advertising in the food industry is a problem that has an impact on both customers and businesses. Businesses that use misleading advertising techniques risk legal and financial repercussions, but more crucially, they jeopardize public safety and customer confidence. It is important for companies to adhere to advertising laws, make sure that their statements are accurate, supported, and not deceptive, but consumers also need to be aware and report false advertising strategies and information to the proper authorities if necessary. We can develop a more wholesome and dependable market for all parties involved by encouraging openness, responsibility, and ethical behavior in the food business. Thank you.